The Florida Workers' Compensation System is designed to provide injured workers with quick and efficient lost wages and medical treatment. You may find yourself asking, if that's the case, why was my claim denied? In this video, we're going to discuss 10 reasons why the insurance company may have denied your claim. If you find this video helpful, please like, share, and subscribe to the channel. Let's get started. No workplace accident or injury. If you weren't working on the day you claim you were injured, or perhaps the employer speaks to your coworkers and they say no accident happened, or even worse, if there is a video recording of your workspace and the accident you described is not visible, the insurance company is likely going to deny your claim. If you file a lawsuit, a judge will ultimately decide whether you had an accident or injury. Your specific injury isn't covered. The big one here is someone claiming a mental injury because of stress. Stress alone is an insufficient cause of a mental injury for it to be covered under workers' comp. As an example, if you're a victim of a robbery at gunpoint while at work, but aren't physically injured, your mental injuries will not be covered. However, if you're the victim of battery during the robbery, your mental injuries would be covered in addition to your physical injuries. Late reporting. You only have 30 days to report your accident to your employer. Don't be brave. This isn't something that can be cured if you report it late. Even if you aren't sure if you're going to need treatment, report your accident and all symptoms. You should do this in a reproducible writing, email, or text in the event that the insurance company ever asserts that you didn't report the accident timely. Lack of witnesses. Having a witness isn't necessary, but it sure helps. The bottom line is the insurance company is going to talk to your employer about whether they believe you had the accident or not. If there were witnesses, document them to the employer so witness statements can be obtained. This will add credibility to your report of the accident and hopefully result in the insurance company acknowledging that you truly had an accident. Inconsistent stories. After your accident, you will report your accident to the employer. You'll also probably go to the ER and possibly another doctor. You may even have your deposition taken. If each time you describe your accident and injuries, you suddenly have new or different facts or new injuries, this is a red flag to the insurance company and may result in them more closely scrutinizing your case and denying your claim. Pre-existing conditions. This is a complex and lengthy topic. It's also one of the most commonly raised defenses. In a Florida work comp claim, you have to show that your accident is greater than 50% the cause of your injuries, inability to work, and need for treatment. So if the insurance company can show that you have a history of similar medical problems, you can expect that this defense is going to be raised. I'll give you an example. If you had a car accident 2 years before your accident that you're trying to get benefits for under workers' comp, and that prior accident, say, involved a car accident where you hurt your low back, you were sent to a doctor, they did an evaluation, they did an MRI, and ultimately the doctor recommended surgery for you. But you decided surgery wasn't right for you, you didn't have surgery, and instead you just settled your case for that car accident claim. And now we fast forward and we're 2 years later down the road after that car accident case, and you had this accident on the job, maybe you lifted a box or something and you're claiming that you hurt your low back. They send you to a doctor, you get a new MRI, and that MRI shows the same kind of findings that were on the prior MRI. When the insurance company gets their hands on that, you can expect that they're going to deny your claim because it's pre-existing. It's the same injury that you had before the on-the-job accident. Lack of cooperation. The insurance company as an entity isn't making decisions on your case. There's no board voting on whether or not to provide you with benefits. Instead, your case will be assigned to a claims adjuster who will manage your claim. They decide whether to provide benefits or not. Adjusters are people just like you and me. They have biases and react to how they are treated. If the adjuster feels like you are not cooperating, they may delay provision of benefits or deny your claim. However, you're not required to give a recorded statement and can refuse same. That's simplified when you are represented by an attorney because the insurance company is not allowed to communicate directly with you when you have an attorney. You intentionally injured yourself. This may sound silly, and I'm happy to report I've never seen this come up in a case I've been involved with, but if you intentionally injure yourself, you're not entitled to work comp benefits. While not a basis for a complete denial of benefits, if you fail to use safety equipment provided to you, this can result in your lost wage benefits being reduced by 25%. Drug use, intoxication. If your employer requires a post-accident drug test and you test positive, it's presumed that your intoxication caused your injuries. Refusal to take a post-accident drug test is treated as if the test was performed and resulted in a positive test. This presumption can be overcome, but these are very complicated and difficult cases that often require the testimony of not only toxicologists, but other medical experts as well. Fighting at work. If a fight occurs at work, the aggressor is never entitled to benefits. But who the aggressor was is not always easy to determine. Case law says that the aggressor is the one who first made an assault upon the other with the intention to injure or kill the other. Even with that definition, this is really fact-specific and will ultimately be decided by a judge. Credibility and witnesses will be very important. Even if you weren't the aggressor, the insurance company may not be responsible for your injuries if the fight was purely caused by factors outside of work. In other words, if the only work connection is that it happened at work fortuitously, this may not be covered. Again, this is very fact-specific and will come down to credibility and witness testimony. Sometimes work comp claims are denied. Trying to overcome that denial can be overwhelming and can seem impossible. If your claim has been denied, call us at 407-531-8477 for a free consult to discuss your case. Thanks for taking the time to watch this video. If you found it helpful, please like, share, and subscribe to the channel. And anytime you have questions, find us online at bdtlawfirm.com, making workers' comp work for you.